Okay, good morning everybody and welcome to our special VCE event, Dear Judge. Before I introduce myself, I would like to begin by acknowledging the traditional owners of the land from which I am speaking, the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past and present and emerging leaders. My name is Tiana. I'm the Education Coordinator here at the County Court. I will be moderating this event today. All attendees will have their cameras and microphones turned off, but the Q&A function is live, so please type your questions in the Q&A box at any time throughout the session, and I will pass them on to our panel of judges here today. Again, just a reminder that your name should be set as your school name, and please do not take any pictures or record this event. With that, it's my pleasure to introduce you to our panel today. Judge Davis, Judge Rozen and Judge Riddell, thank you so much for joining us this morning and giving up your time to speak to us. I might pass over to Judge Davis first for a brief introduction.
Good morning, my name is Sandra Davis. I've been a judge of this court for 19 years, practising half in crime and half in civil. Before that I was a Deputy President at VCAT for about 5 years, and before that I was a barrister. Before that I was an academic in international politics. It's been a long journey for me, but what I do now is basically half civil and half crime, and it's a pleasure to be with you today.
Thank you. Judge Rozen?
Good morning, my name is Peter Rozen. I've been a judge of the County Court for about a year and a half. Like Judge Davis, I practiced part in civil and part in crime. Before that I was a barrister for a little over 20 years, practising in a range of areas, including employment, industrial, general civil, and in recent years in a number of royal commissions and public inquiries.
Great, thank you, Judge. And Judge Riddell?
Good morning, my name is Trish Riddell. I've been on this court for 5.5 years and I sit in the criminal division. Prior to joining the court, I was a barrister for 21 years. My practice was a bit mixed, but it was mainly crime and what I'd call quasi-crime, so disciplinary matters when perhaps teachers were in trouble or medical practitioners were in trouble and facing disciplinary action. In my personal life, I'll just mention I've got 3 children, the youngest of whom is doing VCE, so I've got a lot of sympathy for all of you at the moment and also for your parents. So good luck. I hope we're not dragging you away from muck-up day to be here, but I'm glad that you're here. Thanks.
Thank you, judges. So the aim of this session is to really help students to build and further their understanding of criminal trials, the criminal justice system, and those processes by answering your questions. And hopefully help you have a little bit of a leg up for your exams. So with that, I'll just really remind you, students and teachers, please use the Q&A function. From now, please type in any questions that you might have, because that's really why we're here, is to answer your questions. So if you're waiting for a cue, this is it. Please start putting your questions in. In saying that, I do have a couple to get us started this morning with our discussion. So I might start with Judge Davis. So Judge, what are the purposes of criminal sanctions and how does a judge balance these purposes when they're sentencing?
Well, I think you've all learned that the principal purposes are things like just punishment, denunciation, general and specific deterrence, prospects of rehabilitation, protection of the community. They all have to be balanced in terms of the circumstances of the particular case, the maximum penalty imposed by Parliament, and all the other factors that are personal to an offender, their age, whether they've got previous convictions, the kind of problems that they might personally have. And then there are also the principles of totality and parsimony, which is effectively that the court has to be always careful to impose the least onerous sentence that is consistent with all the sentencing principles, and to be parsimonious, that is to be, to basically impose the lowest sentence that's consistent with all sentencing principles, because the aim of the law is not to impose crushing sentences. And often when we're sentencing people for a range of offences, not just for one offence. And then, of course, you have to take into account the kind of offence it is. Certain kinds of offences are much more serious than others. They have a special place in parliamentary, in the Sentencing Act, Category 1 offences, murder, rape, etc. There are sexual offences which carry a particular seriousness and for which Parliament has dictated that there be a certain sentence imposed, a standard sentence imposed for the sort of type of crime or type of offence that falls within the sort of middle of the range. But generally, balancing all those factors is something that I think we all find very challenging, because the personal circumstances of the offender, for example, if they're a youthful offender, the considerations of rehabilitation and their prospects for the future carry more weight than if they're older. On the other hand, if the crime is more serious, the factor of youth has less weight, and we're not allowed to give it as much weight as we ordinarily would. Similarly, for certain categories of offences, like sex offences, the fact that somebody doesn't have prior offences or prior criminal conduct of that kind isn't something that we can give as much weight to as we would if it was a different kind of offence, for example, an offence of causing injury to somebody as a first offence. But sex offences are regarded with, as are home invasions and particular kinds of interferences with children and particular kinds of offences with circumstances of gross violence. They're regarded as particularly serious, and so some of the mitigating factors that you would normally be able to take into account have lesser weight because the crime in itself is much more regarded as much more serious by Parliament. And then in looking at these personal circumstances of the offender themselves, you've got to take into account do they have a particular impairment? Was there something which do they have intellectual impairment? Do they have mental health impairment? Did those impairments, were they causally connected with their offending in any particular way? And if they are, well then of course a person with a mental impairment and whose mental impairment was causally related to the crime is less of a vehicle for specific deterrence, for example. So you'll all be aware that the aims of sentencing are to denounce crime, to justly punish crime, to deter other members of the community from doing crimes of a similar nature. But specific deterrence really does depend a bit on the circumstances of an offender. If they have limited capacity to understand what they're doing or to do otherwise, then the law takes that into account. Of course, their rehabilitation prospects are always important, and age, of course, is a very important factor in sentencing. And then protection of the community, of course, takes much greater importance when the type of crime is very serious, when it's an offence involving children and sexual matters, and in other categories of crimes with gross circumstances of violence. So we have to balance all of those factors, and I would say my colleagues will probably say something, but that's probably the hardest thing that we do, is balancing all those factors every time we sentence.
Perhaps I'll just add another aspect of that is taking into account victim impact statements, which were introduced as a law reform a number of years ago to make sure that victims had a voice in the sentencing process. And they're often very emotional, and they're often telling us the long-term impact of whatever offence has been committed against them, and that's an important aspect of what we also take into account.
Thank you, judges. Judge Rozen, I guess kind of flowing on from that question, when you come across a young adult who's been involved in a matter, do you treat them any differently because of their age? And I guess that's similar to what we were just discussing.
Short answer is yes, particularly in the context of sentencing, so I'll sort of focus on that area. As Judge Davis has said, as applying general sentencing principles, we're required to look both at the circumstances of the offence and the circumstances of the offender. And an important part of an offender is their age. And it's probably best to understand the way we approach sentencing young offenders to think just briefly about what happens in the children's court. So for very young offenders, that is for minors, they're sentenced in the children's court, with some minor exceptions for very serious crimes where they can be sentenced in this court or the Supreme Court. And the approach that the children's court takes is dictated by statute, and in the children's court it's all about rehabilitation. So general deterrence plays little or no role in sentencing in the children's court. That's not quite what we do here. We apply a kind of hybrid approach to sentencing young adults where we place more emphasis in that general balancing exercise that Judge Davis has explained on the rehabilitation of the offender than we do on other sentencing considerations, particularly general deterrence. So it's not the same as the approach in the Children's Court, but nor is it the approach we take to older offenders. It's a type of hybrid situation. And even then, if the offence is a particularly serious one, then we've got to modify that approach by altering that balance a bit and giving less weight to rehabilitation and more to other sentencing considerations such as just punishment, general and specific deterrence. The experience of this court, we have a lot of young adult offenders and they're often committing particular types of offending. So, for example, driving-related offences, we commonly, and they're serious, they often involve the death of other road users or passengers, and so we face a very difficult dilemma in balancing the future prospects of what might be a 20 or 21-year-old who, because of some really dumb decisions on a particular night, has driven whilst they've been drinking or something like that. Obviously, the long-term consequences for the deceased and their family are very significant. We have often heart-rending victim impact statements, as Judge Riddell was talking about a moment ago. And so balancing all of that whilst not losing sight of the importance of the future of this young person who might have just made one terrible mistake in their life, they're amongst the most difficult sentencing cases that we get, getting that balance right.
Thank you, Judge. So, Judge Riddell, what are some of the pre-trial procedures that are necessary when we're looking at a criminal matter, and what does a committal and a directions hearing involve?
Okay, well, there are a number of pre-trial procedures that Parliament has introduced to try and really manage the volume of cases that come to this court and would otherwise be trial matters. If you can imagine, if every matter had to run a trial in front of a jury, we'd be in an endless backlog. So one of those procedures that's introduced is the committal hearing, which happens in the Magistrates Court. And that's like a filtering out of cases to determine, is there enough evidence for this matter to go to a trial? Or are there some issues with the witnesses or the evidence or the charges that are laid? So that's a really important hearing, a preliminary hearing, where the parties get to hear some of the evidence from the key witnesses, test that evidence, and then often they'll have a discussion about whether they can resolve the matter. And I know from your curriculum that there's discussion about plea bargaining, which is probably an American term, but it's basically the same thing that happens often after a committal hearing. The parties will then know what some of the evidence is. They'll be able to talk to each other about, you know, this charge is weak, but I would plead guilty to that charge, or there might be some other way around it. So plea bargaining after a committal is crucial, and it's important for both ends of the table. Prosecution, if a matter resolves, they know then that they're going to proceed with that matter to conclusion because the accused is going to plead guilty to some aspect of it, or maybe even the head charge of it. They can then inform their victims or their witnesses, the matter's resolved, you don't have to come again and give evidence again, which you can imagine is a great relief to a lot of witnesses. For the accused, equally important because they have certainty. They're not going to roll the dice in front of a jury and see what comes up. They know what they're pleading guilty to, and then the matter comes over to this court for that process. Because of the delays in COVID, when we couldn't get people to come in and be on juries, Parliament also enacted some other law reform to introduce preliminary hearings in this court. Tiana's asked me about directions hearings. So every matter that comes here, first off, has a directions hearing, and that's where a judicial registrar or a judge will hear from the parties, are there prospects this matter can resolve? Can I make some directions to make sure you provide paperwork or material to each other's side Can we have in this court some preliminary cross-examination, for example, of a witness who might not have been called at a committal to see what can be resolved? One of the other big things that Parliament introduced during the COVID pandemic to help with the backlog is a hearing called a sentence indication hearing. So an accused can ask to go in front of a judge and get an indication, if I plead guilty to X offence, what sort of sentence will I get? And it might be that they're told it's imprisonment, or it might be they're told, well, I would consider a community correction order, or a combination of both. And when it's imprisonment, they're even told these are the sort of figures. So we do a lot of those hearings and they're very successful because often what people just want is certainty. And so when a judge says, I would not imprison you, or I would imprison you and these are the figures, they then have a discussion with their solicitors and barristers and they're able to make an informed decision. And we're finding a lot of people just having that certainty will then plead guilty and the matter can then proceed to sentence. So that's one of the other preliminary hearings that's been introduced more recently.
Could I just add something to that? It's been terribly important during the COVID pandemic because, as you all know, if you plead guilty to an offence, there comes with it a sentencing discount. And for anybody who pleads during the currency of the COVID-19 pandemic, which extends to the backlog caused by the COVID-19 pandemic, the Court of Appeal has ruled that people are entitled to an additional discount in their sentence over and above the usual discount. So it's a particularly fertile time for people still to take advantage of the possibility of resolving their matters by plea of guilty.
I might just add to that as well. Judge Riddell spoke about committal hearings in the Magistrates' Court and the important role they play in the criminal justice process. They're also quite controversial in the sense that there's a perception they extend the time that cases take to come through the system, and they can also lead to witnesses being cross-examined on more than one occasion. As a result of that, for years, governments have grappled with reforms to the committal processes, and there have been some changes made in the past that you may have learnt about, particularly in relation to sexual offences and the limiting the role that committal hearings in the Magistrates' Court play in those sorts of cases. And there are further reforms which have been proposed by the government. And I just raise this because the court played a role in the law reform process by having a committee of judges who comment on proposals that proposed law reforms that the government has. And I'm on that committee at present, and it's an interesting way of being involved in the development of the law as well as dealing with individual cases as we do. And it's an important part of the law reform process because often the judges of this court collectively will be able to anticipate the effect of a particular reform, which may be positive or negative, and provide that advice to government to perhaps modify proposals the government has. It's just a form of advice that the government gets, and it's an important role that judges play, not just at this court, but at the Supreme Court and the Magistrates' Court as well, to be involved in reform of the law, because we can draw on our experience, our collective experience of how cases run. And ultimately, if that process is working well, it'll mean that law reform is more effective in the future.
Great, thank you, judges. And I think all of you giving examples of those reforms is very relevant to students because I do believe that features quite heavily. So I'm sure they'll be able to use that in their exams coming up. And kind of flowing on from that, and Judge Davis, you mentioned some of the COVID-19 changes and I guess effects. And we have a question here. I believe it's from Camberwell Grammar, but just a reminder, if you can please change your name to your school name so we know exactly who they're coming from. But they've just asked us, what are the continued effects that the courts are still seeing from the pandemic? And you've touched on this already and how they're being managed, and whether you have any other examples of those kinds of flow-on effects.
Well, that's the sentencing, the additional sentencing discount is probably the most obvious and important flow-on effect But the other thing, of course, is the recognition in all of the sentences that we impose that prisoners who've been on remand for a long period of time prior to trial, because there was a suspension of trials, people who might have ordinarily been on remand and kept in prison for 9 months, 12 months prior to trial, may have spent 2.5 years in prison in very, very onerous conditions. Every time they left the prison, if they came back, they would have to have 2 weeks in isolation. There were no programs. A lot of the rehabilitative programs that would normally be available in prison to them were not available. So the conditions...
no visits.
No visits, exactly. Very, very limited interaction with each other and with the outside world. They're very onerous conditions, and so those are matters which are being taken into account and will continue to be taken into account for as long as there are prisoners who were affected by that period on remand. Anything else?
I was just going to add, I think I've perceived an effect on the legal profession to some extent, that because we had remote hearings during the COVID period, in other words, people appearing, and you might have seen the funny videos of people appearing from home in their pyjamas and so on. But in all seriousness, I think it has led to perhaps a reduced informality about the way court proceedings are perceived, not just by lawyers, but by people appearing in court as well. You know, I've had situations where people have appeared in court from the mobile phone whilst they're sitting in their car by the side of the road. And obviously the courts want to try and be flexible, but there needs to be a limit to that, because the formality of the court process and the seriousness of it is a very important part of what we do to ensure that there's the appropriate level of respect by the community for what the courts are doing. So I think there's a bit of that sort of informality has crept in, which maybe over time we'll go back to where we were. On a more positive note, though, we've learned to be much more flexible in the way we conduct our hearings and much greater use of technology. I think all the courts found that they were, relative to the rest of society, perhaps lacking in the use of technology at the start of the pandemic, and we had to learn very quickly. And I think that's been a very positive development, the use of technology.
I'll just jump on what Judge Rozen said. In relation to technology, one of the great benefits is we've been able to deal with a lot of cases that are in the country. So as you probably know, we've got our county court in Melbourne, but we sit all over Victoria. And often those cases have to wait until a judge is on circuit, whether it's Warrnambool or Sale or Mildura. So we've been able to use the technology to deal with those cases with the judge sitting in Melbourne, and that's certainly helped with the issue of delay.
The only thing one should remind you, of course, is that all of that is subject to the fact that no criminal trials before juries could take place. Yeah. And so the technology has been very helpful in dealing with all other matters, but not in relation to... That's why the backlog is as it is, because no jurors could come to any court, and so no criminal trials could run. But all other court processes and outside crime and civil and commercial, the court basically just converted everything to Zoom hearings and without juries, and things went fine, and we don't have a backlog. But the criminal trial process being what it is, that's where the backlog has been most acute and will take the longest to sort out.
I did hear in Scotland they were having a jury sitting in a movie cinema, beamed in watching the court process, which did make me wonder about the whether they would fully appreciate what they were dealing with rather than watching a movie.
Thank you, judges, and I think that actually is a really great, information for students as well in terms of access to justice, and I guess how things have evolved in terms of accessibility for people through that technology, and things you're saying about the court becoming a little bit less scary and a little bit more informal in some ways. I think students can take some answers for perhaps those types of questions as well from what you've spoken about.
Just in terms of that access, because I know that's part of your curriculum, of course, if you're dealing with someone in the country, it saves them the time and the expense of trekking into Melbourne for a hearing.
Perhaps I could just add to that. Before I was appointed as a judge, I was senior counsel assisting the Aged Care Royal Commission. Some of you may remember that a few years ago. And looking back on it now, and this was pre-COVID, so 2018 it was, we had a hearing in Darwin and we flew witnesses, including expert witnesses from all over the country, to this hearing in Darwin, and some of them had to sort of touch down in the morning and give their evidence and then fly back to Sydney or Melbourne or Brisbane or wherever it was in the afternoon. And looking back on that now, that just seems crazy. Like, that just would not happen now. The expense, that's all public money being spent, and it just wouldn't happen that way now. But at the time, I don't remember anyone in the room saying, why are we doing this? This is all very expensive. It was just the way things were done at that time, whereas now we have a completely different perspective, and I could imagine that hearing being conducted. It would still have to be in Darwin because it was a National Royal Commission, but certainly the professional witnesses would all appear remotely, and most of the other witnesses probably as well. So that's a really big change in the way the whole legal profession and government think about the conduct of hearings, I think.
And it is the case also that in the running of criminal trials, technology has contributed to the much greater efficiency in running of those, because many witnesses can appear remotely, and sometimes you'll have a couple of witnesses, and it makes a very big difference to their availability and to the smooth running of a trial that they be available. And if they can be available remotely, well, then we deal with them remotely. That does make a big difference to the length the trial takes.
Great, thank you, judges. As I said, I think that from my experience with looking at exams, types of questions like that do come up quite often. So I think you've given students a lot of inspiration to answer those ones. And thank you to Camwell for asking that question. It sparked a really great discussion. And I will just note, if we do talk about anything that you would like us to elaborate on, please type that in the Q&A box as well, and keep those questions coming in. So I might direct the next one to Judge Rozen. Could you tell us a bit about how a judge goes about determining a non-parole period, and what potentially statutes or guidelines or things might help to inform a judge with that?
Yeah, that's a good question. So as you'll all be aware, most of the sentences that are imposed in this court, in sentences of imprisonment, will be for periods of years and months rather than just months, which is a sort of sentence you might expect in the magistrate's court. And so we are often in a position where we either have to impose a non-parole period, that is the minimum term that a person must serve in prison before they're eligible for parole. Of course, it doesn't mean they get parole when they're eligible. That's not something that judges have any control over. There's a parole board that makes those decisions. Our task is to identify the minimum period that they have to serve in prison before they're eligible, before they can apply for parole. And there's no specific proportion or ratio of the total sentence, or the head sentence, it's sometimes referred to, that we apply. But there are some rules of thumb that we apply, and that have been endorsed by appellate courts like the Court of Appeal. And most judges operate around about the 60%, 2/3 of the head sentence as a sort of rule of thumb in terms of a non-parole period. So if you're imposing a head sentence of 3 years, you might be looking at around about 2, just in very broad terms. But that will vary depending on the circumstances of the case. So that's the really important thing. We don't just arbitrarily say it's this percentage. We've got to consider the particular case. So for example, if it's a young offender, we might want to have a lower non-parole period. It might be, for example, half or a little bit more. And the purpose of that really is to ensure a greater period of supervision after they are released. So it's important to remember what parole is. Parole is you get out of prison earlier potentially than the total sentence, but you're released under supervision. And so we have to assess the importance of that for a particular case. So we'll take into account, for example, whether the age of the person, whether they have sort of drug or alcohol issues, what sort of support they're likely to have in terms of family once they're released from prison. And another consideration is whether they've pleaded guilty or not guilty as well. So that's another matter to be taken into account. And we factor all that in and then determine what an appropriate non-parole period is in a particular case.
Thank you. We do have a question, again from Camberwell Girls Grammar. So Judge Riddell, I might direct this one to you. Can you provide some insight into the barriers that parties might face accessing the court, and especially in relation to perhaps cost and cultural difference? And Judge Davis and Judge Rozen, if you then want to elaborate, please do.
Sure. Well, there are a lot of people who come before our court who, as you might imagine, have committed an offence because a whole confluence of circumstances through their life has led to poverty, homelessness. They might be victims of abuse themselves, and those are real barriers to them engaging in the legal process. You heard the example from Judge Rozen about young people, and I always tell young people like you, the most common time we see you is when you get behind the wheel of a car, so be careful. Those tend to be people who commit offences for the first time, but a lot of people through that disadvantage in their life are repeat offenders and come to us having committed some serious offence, and often drugs and alcohol are a sadly significant part of that. So you'll all be aware of legal aid. Victoria Legal Aid exists for people who have a means test that says they're not able to fund themselves and their representation, because of course legal representation is expensive. Victoria Legal Aid community legal centres are really important places for those people to go, but money is often a real barrier. Other things like cultural difference can lead to people just not understanding the system or how the system works, but there are regularly interpreters in court. I had a French interpreter in court last week for someone here from France on a tourist visa who'd committed some drug trafficking offences. That's one aspect that can assist people in their access to justice. And I'm sure you're all aware of the Koori Court and the role that it plays in recognising Aboriginal culture, because of that understanding that in a general sense there's been generational trauma and disadvantage to Aboriginal people. And there's been a number of commissions, as I'm sure you're aware, looking at the over-representation of Aboriginal people in our system. And so that's a very specific aspect introduced by Parliament to allow those cultural factors to be brought to the fore. Yeah.
If I could just add to that, obviously the law doesn't just take into account the specifically potentially horrendous circumstances of First Nations people, but the Bugmy principles, which you will have read about in the High Court, will basically be available to any offender who comes from a family background of great deprivation, exposure to violence, exposure to sexual violence, to physical violence, to alcoholism, and of course many offenders that we do see, and that's probably why this court, in a sense, as a trial court, is a particularly difficult court to operate in, because it's not just the victims who may have terrible consequences from the injuries they suffer at the hand of the offender, but the offender themselves, when their personal backgrounds come to be examined, as they always are once they come to be sentenced, reveal themselves to be horrendous as well. And so the law, through the courts, has provided an opportunity for us in synthesising all of the factors that are relevant to sentencing to give particular weight in assessing the moral culpability of an offender, giving weight to the extent of disadvantage that they may have suffered themselves, and to consider that in some circumstances that disadvantage has led them to be unable during their formative years to form the kinds of moral compass that we would expect of people not subjected to that level of deprivation and disadvantage. And we're talking about people where they're raised in circumstances not just of extreme poverty, but where they're exposed to drug use, where there's prostitution in the household, where there's gross violence in the household, where pretty much they are left to fend for themselves. These are circumstances often of great deprivation, but also of great interference. They may have been the subject of sexual abuse and been victims of violence within the household themselves. So those matters are particularly relevant when we assess the moral culpability of an offender, which we have to do when we consider the offender's personal circumstances.
Perhaps I could just add to that with an example of a case that I've recently been dealing with in the court, where a young man in his early 20s has been charged with and is pleading guilty to very serious offences involving child abuse material, which is a phrase you may be familiar with, depictions of pornography involving children on the internet, which sadly is an all too frequent type of case that we get in the court. The unusual circumstance about this case is that the evidence before the court, which is accepted by the prosecution, is that he was introduced to child pornography by his own father. When his father, who he had very little to do with whilst he was a child, came into his life when he was a teenager and introduced him to child pornography, and that was part of the father-son relationship extraordinarily. And so it's a particularly graphic example of the impact of childhood trauma that he suffered manifesting in the way that he has offended later in life. And it's a good example of how complex sentencing is often in the court, that whilst at first blush you might think, well, that's terrible offending and it obviously deserves a particularly serious penalty, but then when one delves into it a bit more and understands the personal circumstances of the offender, it becomes more complex. It doesn't change the fact that it's serious offending. Of course, it's still very serious offending, but it does provide some explanation. And the other evidence in the case is that the offender suffers from a range of mental illnesses, which is another consideration that we have to take into account under a case that you may have heard of called Verdens, the DINS, which is often something that we have to consider, the effect of mental ill health on the part of an offender and what role it's played in their offending. And so it's just another example of the things we have to take into account in sentencing.
Great, thank you, judges. And I think, for students and for everybody, that's such a good example of sentencing is never a straightforward or a simple task. And I think this is a great discussion for students to understand that balancing act and that difficult task that's in front of you. We have a question here from the virtual school of Victoria, so I might pop this one to Judge
real school?
Davis. They are a real school, still online, so this is, I'm glad that we're able to have them with us and this is accessible for them today as well. They would like to know if you can provide a little bit more information on how the Koori Court operates and what are the main benefits of the Koori Court system and the way that those cases are heard.
So the Koori Court system really is designed to not provide a different type of, it doesn't provide different justice. Ordinary sentencing principles apply, but it provides a different context during which a plea can occur. And so really the sentencing process, I sit on Koori Court quite frequently, and the process is this. Firstly, there are certain types of crime that are not eligible to be dealt with by the Koori Court, and those involve sex crimes, for example. But in other categories of crimes of violence, other serious crimes that would normally come before us where the offender is likely to spend a number of years in prison, the aim is to engage as part of the plea hearing. We have what's called a sentencing conversation. So the court will start in its usual way. The judge will be sitting behind where they normally do, and counsel will open the case and we'll hear a summary of the offending. But there'll be two elders from the First Nations communities who will have had an opportunity to discuss the matter with me, for example, before the hearing. And then as soon as the matter has been opened and the basic facts surrounding the offending have been outlined, I leave the bench, I go away and take off my uniform, and the three of us, myself and our two elders, come and sit at the bar table with the offender and the offender's support group, sometimes family members, sometimes support workers who will be in the mix behind them or with them at the table, and there will take place what's called a sentencing conversation, where the elders will inquire a bit about the background of the offender, their mob, where they come from, whether they have any connections in the community, what their level of cultural awareness is, how they have dealt with their Aboriginality throughout their childhood, what factors have perhaps led them to go astray, as it were, and to offend. And that conversation is a conversation that takes place between the elders and the offender, and we just sit back and listen to it, occasionally ask a few questions. But it's a conversation in which the principle of bringing a young First Nations person before their own elders is the critical part, because in their own culture, whatever shaming would take place with that group of elders from their own background. And so this is a powerful way sometimes of drawing out people's lack of connection, their recent discovery about connection, who their mob is, where their mob comes from, what contacts they've had. There are support services, obviously, in prison for prisoners on remand, Aboriginal legal services, etc., that try and make connections. But sometimes people are a long way from country. They're a long way from where their mob originally came from, or they've lost connections, and the elders are there to help elicit information about all of that. And the person who runs the Koori Court in the background will often have made some preliminary efforts to engage the offender with their mob. And then at the end of that conversation, really the normal plea hearing resumes. So the elders and myself will leave the court, we'll come back and I'll be robed and we'll hear the remainder of the submissions, and then we'll go away and sentence in the usual way, and the elders don't play a part in the sentence, although they will have read the material and we will have had a discussion about it. It's a powerful, there is a consideration when you sentence. If a Koori offender volunteers and participates genuinely in the process, the sentencing conversation, you have to take that into account in sentencing them, that they did so. It's quite a powerful process, and one person who I recently had before me, who he and his brother were involved in some fairly serious crime, and they're young men, both exceptional artists, and they produced to me some of the art that they had produced in prison through their reconnection with mob and with people, and also being in an environment, obviously, in prison, free from drug use and free from a negative peer group. They had produced artworks of an extraordinary quality, which they were selling from prison with great success. And when they brought in examples, there were probably 12 paintings that they took pictures of. I would have bought all of them if I could have. They were just breathtakingly beautiful, but they reflected truly the ability of people who were otherwise inarticulate, angry and aggrieved for reasons that might have had to do also with their own background, the capacity to express themselves emotionally at an artistic level. And so Koori Court does provide an opportunity to see things of people that we would not see ordinarily. So it doesn't affect how they get sentenced, it's just a different way of engaging with an offender prior to sentence. So.
Thank you, Judge. Judge Rozen,
Yeah, I was just going to add, it probably goes without saying, but Koori Court, you've got to plead guilty to, so it's only a sentencing court. I also just wanted to briefly mention another one of the specialist courts within the county court, which is the drug court, that you may have heard a little about. And it's part of what's referred to as a therapeutic approach to the criminal justice system, and it involves a more holistic approach to deal with those sort of broader concerns that Judge Riddell referred to earlier, which might be homelessness, drug abuse, alcohol abuse, and so on. So it's more aligned with looking at the complete person and what it is that's brought them into the criminal justice system. And it's part of a worldwide initiative, so there's lots of drug courts in many different countries which have been the subject of evaluations, and there's quite an extensive literature that's been written about this approach. And it's a particularly interesting, I think, way of trying to address broader causes of crime and to be of greater assistance really to helping people who find themselves, involved in drug abuse and alcohol abuse and so on. And so it brings in a range of professionals, counsellors, psychologists and so on, working together with the judge to approach those sort of broader causes of crime. And so it's another very interesting initiative within the court.
I think just add on to that in drug court, the judge brings the offender back almost about weekly to keep a check on how are you going, to talk to the support group, whether it's counsellors or drug and alcohol counsellors, mental health counsellors. So it's a very hands-on, as Judge Rozen said, therapeutic approach, recognising that few people are truly bad and that a lot of people have just had bad circumstances that have led to that, and drug addiction is a serious one of them.
Great, thank you, Judge.
Can I add one thing? It's also, I think, an economic consideration which is very, very appropriate, that society is so affected not just in terms of the violence committed by people who are under the influence of drugs, but also just in providing the services that they need, that helping people deal with addiction along the way, recognising that people fall off the wagon often and they have to have a huge amount of support to stay off drugs, and often other supports, a safe place to live and some sort of source of income in order to maintain their ability to stay off drugs or to become so desperate. It's a particularly, it's an investment in the future health of society, because we would probably say that virtually 90% of the violent crime that we see is crime committed by people who are addicted to methamphetamines. I don't think there has been a case of violence that I have dealt with in the last 10 years that hasn't been committed in circumstances where the offender is drug affected and seriously drug affected, and affected by a drug which makes people highly activated, stops them from sleeping, and very, very disinhibited and aggressive. Yeah. So that things that would have occurred in the past where somebody might punch somebody, people are running around with golf clubs, machetes, all sorts of iron bars, committing appalling offences, but in the grips of an addiction.
Great. Thank you, judges. I think that's a really important discussion about how the court is evolving to address offending and the rehabilitative aspects as well. And I know that that's a really important part of the curriculum. So thank you very much for that discussion. It's really, really important generally, but especially for our students. I might ask one more question and then we might have to wrap up a little bit. So I might direct it to Judge Rozen, but then of course judges, please add anything as well. Maybe you could tell us a little bit about how judges direct juries and perhaps any challenges when a case is particularly high profile of directing a jury.
Yeah, another really good question. So it's one of the most challenging and I think most satisfying parts of the job of a judge sitting in the criminal division of the court is working with juries. I think, and I suspect I speak for all of the judges, certainly both on the panel, but generally in the court, we are all really in awe of juries and jurors and their commitment and application to the job. So if you sort of think about it, with this random groups of people coming into this building, not knowing what's ahead of them, and then 12 of them find themselves sitting together for, it might be a few days, it might be a few weeks, often hearing very confronting and challenging information about traumatised witnesses, violence, sexual offending, and so on. And certainly my experience of exposure to juries, both working as a barrister and now here as a judge, is that invariably people really apply themselves to that task and give it their all, really. In terms of directing them, obviously we play a very important role in assisting them with understanding what the law is. So it's very important at the outset that the respective roles of judges and juries are made clear to the jury. That is, it's their task to determine what the facts are and to determine what the correct verdict is. That's their task. And our task has nothing to do with those matters other than assisting them to perform their task. So we're there to explain the law, both in terms of procedure, so we have to explain to them some of the concepts that you students will be very familiar with: the burden of proof, the onus of proof, the approaches that can be applied, the presumption of innocence. They're really fundamental principles that we explain and emphasise in the directions that we give to juries. We give them what are called preliminary directions, so before they hear any of the evidence, we explain those basic concepts to them. And then at the conclusion of the evidence, we give them directions which assist them in arriving at their verdicts. We'll often repeat some of the directions that we gave early on about those fundamental principles. We can also, and more, we're called upon to give directions during the course of trials now. So there's an act called the Jury Directions Act, which very comprehensively sets out the directions that we're required to give to jurors and sets out a process that requires a conversation between the defence barrister, the prosecuting barrister and the judge to decide what are the appropriate directions that the jury should be given in that case. And that's a process that we follow in each and every case.
Can I jump in?
Please.
Oh, sorry, Sandy. I'm conscious of time. So just two things in relation to jury directions. One is a really good example of some law reform where the law is catching up with what society understands about sexual offending, is we are now required, and it's a great thing, to tell juries some directions of law about common misconceptions in sexual offending. So we tell juries, for example, some people complain immediately, but some take a long time to complain, and you must take that into account when you're considering delay. Some victims of sexual offending will keep contact with the person or stay in a relationship. It doesn't mean there was consent. So those are some directions that we now give routinely to make sure the jury's informed about, well, there might be common misconceptions, but actually experience shows this is how people react. They don't necessarily complain. They might keep contact with an offender. They might stay in relationship, and there are all sorts of reasons you should consider. So that's one thing I wanted to say. The other thing I wanted to say about directions is one of the challenges is, of course, technology. So we have to warn juries, you must not Google any person, anything about this case, anyone involved in it, and if you become aware another juror has done their own research about it, then you need to tell me because there'll be consequences. We'll have to start again. And in fact, I've had to refer one juror for investigation because I found out that they had done their own Googling about some aspect of the case.
Yeah, and there are criminal sanctions. It is an offence in Victoria now for a juror to conduct their own research, and people may not realise, firstly, that their deliberations are confidential, but also that if they get a conviction in relation to that, they may not be able to travel overseas, and they won't be able to go to the United States, for example. So there are consequences that we have to make them aware of. I just wanted to add one thing, which was that it's a very important discussion that we have with counsel under the Jury Directions Act that has made life a lot easier for us because it gives the barristers the responsibility of engaging with us and requesting the directions that they want. Traditionally, barristers might indicate the sort of directions that they want, but they would leave it to the judge to do the charge, and then they would take what we call exceptions. That is, they come back and say, well, actually, you should have done this, you should have done that, you should have done this, and the judge has to decide whether or not to call the jury back and redirect them. Since the Jury Directions Act has been in place since 2018, I think, it's been a wonderful process of engagement. It also means that the Court of Appeal, when looking back over a conviction, will say, well, this should have been discussed by counsel wasn't discussed by council, we're not going to entertain appeals where you had the responsibility to say what you needed and what you wanted at the time, and therefore that also means that it wastes less of taxpayers' money on useless appeals. But that engagement with council is very important. There are some judges who will actually go to the point of, as I do, producing a draft charge that's been settled with council, so that when they sit down to listen to the directions of law that one gives a jury, they know what's going to be said, and they will have had the opportunity to object, to refine, or to give their feedback on it. And that means that it just means you don't have to come back and redirect. It's sometimes feels a bit counterintuitive to be a judge who's supposed to be in control of the law, who knows the law, who then comes back and says to the jury, well, actually, no, when I said this, I actually meant that, and when I said this, I forgot to say that. So the Jury Directions Act makes it a much smoother process, I think, and a much more credible one for us all.
Well, thank you so much, judges. We'll start wrapping up now. Unfortunately, I wish we could kind of keep going forever, because I'm sure you have so much insights to pass on to students. So thank you so much for joining us this morning and for having this discussion, and I think it's been very valuable for the students. Was there any last words of advice or encouragement you wanted to provide before we wrap up?
Well, for those of you considering a career in the law, there are endless possibilities. So firstly, wait till you enter the world and you'll see just how many possibilities there are. There is a lot of good work to be done in all sorts of places that you wouldn't now know about, that you may discover. So
that's it. There's all sorts of aspects to law, not just crime that we've been speaking about today, but whether you become a lawyer in a corporation advising on contracts, or whether you become a media lawyer, or whether you're working within the mental health space in law in that aspect. There's all sorts of different dimensions to it. We all love it, clearly, and recommend it. And apart from that, just good luck.
good luck.
I might just add by emphasising something Judge Riddell said earlier, and that is make good decisions when you get behind the wheel of a car.
Thank you, judges. As I said, thank you very much for giving up your time to join us this morning. I'm sure it's been extremely beneficial, particularly for the Year 12 students about to sit their exams. Teachers and students, thank you for joining us. We really appreciate your time and your participation. Thank you to those of you who submitted your questions. As I said, Year 12s, good luck for your exams. Year 11s, good luck for your exams and for moving into your final year of school. If you haven't already, please visit our website and check out our free educational resources. There's a lot of great fact sheets, case studies, things like that for you to have a look at. This video recording will be made available to you after the session, and once that is ready, we will ensure that we let you know and send you the link for that one. There will also be a quick survey to complete after the closing of this session, so if you have a moment to fill that out, we would really appreciate it, so that we can continue to make things like this as useful as possible for you. That concludes our event today. Judges, thank you so much for your time.
Thanks.
Thank you everyone
Thanks,
for coming.
Jen.
Have a lovely day. Thank you.